the breakdown theory as grounds of divorce under the Dissolution of Muslim Marriage Act is an judicial innovation. So these two breakdown grounds of divorce are: one is non-payment of maintenance on account of the conduct of the wife. So, non-payment of maintenance by the husband, irrespective of the fact whether the failure has resulted on account of the conduct of the wife. This is based on the interpretation of Clause 3 of Section 2 of the Dissolution of Muslim Marriage Act 1939. And the second breakdown ground is total irreconcilability between the spouses. So when there is total irreconcilability between the spouses, or if we may use the term common in modern matrimonial law of Western countries, both the communist and non-communist countries, the marriage has been broken down irretrievably or beyond the possibility of repair, or expressed by as Justice Krishna Iyer in Aboo Backer versus Mannu in 1971 in Kerala High Court. So these two breakdown grounds are available to wife alone and not to the husband, as judicial divorce at the instance of the husband is still not recognized in Muslim law of modern India. So, besides that, we would like to the last or the final ground of divorce, about which we have previously discussed to some extent, and that is apostasy. So, under Muslim law in modern India, the rule came to be established that apostasy of either husband or wife operated as a complete or immediately dissolution or instant dissolution of marriage. Now, after the coming into force of the Dissolution of Muslim Marriage Act 1939, the position is as follows. The apostasy of the husband still results in an instant dissolution of marriage. Thus, where on the apostasy of the husband, the wife married another person even before expiration of the iddat period, it was held that the wife was not guilty of bigamy, as it was decided in the leading case Abdul Ghani versus Azizullah in 1912 by the Calcutta High Court. And the second important ground of dissolution of marriage on the ground of apostasy is if a Muslim wife who belongs to another faith before her marriage reconverts to her original faith or to some other faith, then also it results in the instant dissolution of marriage. And the third one, that is the apostasy of a Muslim wife, does not result in the dissolution of marriage, instant or otherwise. Apostasy of the wife does not bar her right to sue for divorce on any ground, as specified in Section 2 of the Dissolution of Muslim Marriage Act 1939. So, in this video, we already discussed before that about the 8 different fault grounds of divorce as provided under the Dissolution of Muslim Marriage Act 1939. So also the breakdown theory or grounds of divorce as those were innovated by the judges under judicial decrees. So also the last important ground, that is apostasy. So in that case, how instantly a marriage is dissolved. So finally, regarding talaq or repudiation of marriage by the wife, and as per the very provisions of dissolution of marriage, the very option is always available to the Muslim female or the Muslim wife, at whose instance filing a suit in the court for a divorce by citing the various 8 grounds which are considered as fault grounds of divorce as provided under the Dissolution of Muslim Marriage Act. So also the breakdown theory or grounds of divorce as innovated by the judicial machinery in India. So almost we have discussed all the provisions of Dissolution of Muslim Marriage Act 1939 regarding how a Muslim wife is entitled to file a suit for judicial divorce. And besides that, lastly, we have discussed regarding apostasy and how apostasy is a ground for instant dissolution of marriage, and the various traditional provisions under Islamic law. So also the provisions of modern Islamic law as prevailing in India. So in next video we would like to discuss about the legal effects or consequences of divorce under the very provisions of Dissolution of Muslim Marriage Act 1939 as provided under the fault grounds, and where we found there are 8 different fault grounds which are available to a Muslim wife to divorce or to dissolve her marriage on those 8 specified fault grounds, and also the breakdown theory or grounds of divorce, as us we have discussed two important breakdown theory or grounds of divorce. One is non-payment of maintenance on account of the very conduct of the wife, and the second one, the total irreconcilability between the spouses. So also we have discussed regarding how apostasy is one of the important ground regarding dissolution of a valid nikah or a Muslim marriage, as it is presently in the following by the Indian Muslims under the very provisions of Dissolution of Muslim Marriage Act 1939, so also the various provisions of Quran and Hidayah or Sunnah or Hadith, and also the very views and opinions of the Muslim Qazis, mullahs, experts, so also Prophet Muhammad. So in our next video, we would like to discuss about the very position of maintenance under Islamic law.